Hey out there, legal warriors. In this video, I'm going to cover a very important concept in the law that applies to criminal cases: transferred intent. What does that mean? Where is it useful? And how can it kill so many defenses that people really don't expect? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, as always, I'm just going to jump right into it. So if you have any idea about how the criminal law works, usually most crimes need something that in Greek would be mens rea, or what I like to say of as an evil intent, right? Some type of intent to do something that constitutes a crime. For the most part, if a person doesn't have wrongful intent, things are not going to be a crime. There's some exceptions, like there's regulatory laws, like most fishing and hunting violations don't necessarily require intent. But when it comes to punishing someone with a criminal conviction, with jail, there needs to be some type of criminal intent. And that's where this concept can come in that could make someone's potential criminal liability more broad than they otherwise might think. And that's the concept of transferred intent. So what do I mean by that? There's a couple examples I can think of to try to make this more clear. Let's say that we are dealing with an assault type situation where you are in an argument with somebody and you've got a drink in your hand and you throw the drink and you meant to throw it to the right hand side of the person, but instead it hit him right in the face. You hit this person right in the face with your drink, even though you meant to throw it over here. You didn't mean to throw it at them. You threw it right at their face. Well, in that case, the defense might be arguing, hey, I had no intent to harm this alleged victim of assault, therefore I shouldn't be charged with assault. But there's this concept in the law called transferred intent. So in that case, the prosecution would say, if the person, the suspect who is throwing the drink, intended to throw the drink, then the intent transfers to where the drink ended up, on that person's face. Sort of, you're assuming the risk, right? If you intended to throw something and there's some level of foreseeability it could have hit someone else, that intent, that purposeful act, means now that intent transfers, and that's that evil intent that the prosecutor needs to now assert that you're guilty of an assault, even though you're saying, I never meant to hit him. Well, if you meant to do the throwing, then and it hit someone, think about it as they're going to say you're responsible because you intended that original action. So what's another wrinkle on that? Well, let's say the situation is, you're playing a Wii game, right? Anyone remember the Wii? I don't know if people still have that, but there's remotes. You act and you do things with the remote, right? You're playing this game. You're playing tennis. Bam, bam, and then whoop! It slips out of your hand and hits that person. Well, in that case, that would not be transfer intent because you had no intent to ever throw that remote. That was an actual accident. And for the most part, the criminal law does not penalize accidents, right? As far as accidental actions, there is, if there's criminal negligence, criminal recklessness, there's things in the particular assault laws, and we can name a bunch of laws where we can say that certain types of accidents can be turned into crimes. But in this situation, there's no purpose, there was no volitional intent to let go of that Wii remote, and therefore transferred intent would not apply in that situation. And I think we would have a very strong case to stand up in that situation. But hang on to those remotes closely. Another type of case situation that we can see transferred intent, at least what I think about it that way, is malicious mischief charges. And there's a little bit of a different wrinkle on this also. Malicious mischief is a bunch of strange sounding words right there, malicious mischief. But it's basically property damage. You're guilty of a crime in Washington State of malicious mischief if you knowingly and with malice purposely, damage the property of somebody else. So not accidental damage, but knowingly it was some type of malice, also evil intent. And the situation, most of the time it's pretty clear, right? We don't have to worry about transferred intent. You get mad at someone, show me your phone, who are you cheating on me with? And, oh, that's who. You take the phone and you slam it to the ground and it breaks. Well, you intended to throw the phone on the ground, you intended to damage it, pretty clear that would be malicious mischief. But what about another type of situation where this can come up, where I've seen it come up? You're having a fight with your significant other, a verbal argument, and you decide that you're going to leave the house, and you've been yelling and screaming, and you storm out and you slam the door. And as you slam the door, the glass breaks. Well, did you intend to break the glass? No. But you did intend to angrily slam the door as you left, and while you had no intent to break the glass, you intended the act in anger that caused the glass to break. Therefore, that's, in my way of thinking about things, is transferred intent. The intent to angrily slam that door, it was foreseeable the glass could break. Therefore, they're going to assert that you're guilty of malicious mischief, even though in your head you never wanted to break the glass, right? Now, you can tell it's very fact-specific. Let's say you just tiptoed out and you're happy and there's no fight going on and you open the door and it breaks. Well, then it's more clearly an accident. There was no possible malice because there's no anger or fight going on in that situation. I've also seen cases where someone slams the door and the wedding picture falls off the wall because you slammed it so hard and the glass breaks on the ground. Well, the police are going to say, hey, you had a fight. You took the chance when you acted that aggressively, the thing fell and broke. So now we're going to say that intent transfers, and now you're going to be guilty of a crime in their eyes. Now, again, this is fact dependent. We might have a decent factual argument there, but we're probably going to lose the motion to dismiss for a Napstead motion saying, hey, it doesn't state a crime because of that theory of transferred intent. I think the third type of situation that I can imagine, maybe this is more of a movie imagination. I've not seen this one in real life, but let's say you are, the type of person, you're upset with somebody and the suspect writes out a threatening note, right? You write out a threatening note and you meant it to go to Mr. X and instead it went to Mr. Y. Well, you intended to threaten Mr. X. Mr. Y happened to get the note. They felt threatened. Well, that intent's going to transfer. You intended to make a threat to someone. This other person got it. Then maybe they are also claiming that an intent transfers and it's not a defense that you only intended to threaten Mr. X and not Mr. Y in this situation. So why I bring this up is because many people think, hey, it was an accident. I didn't mean to cause the harm that my actions allegedly produced. And if there was some type of volitional act that you did on purpose that somewhat foreseeably could cause the harm that's being complained of, that theory of transferred intent can say, hey, you intended the act, therefore you are responsible for the outcome, which in many cases can be a criminal charge. So how do we deal with this? We just really pay close attention to the facts. Hey, it wasn't foreseeable. There's no way when this person threw the water bottle on the couch, they could have suspected it was going to pop up and break the plant that was set over there. The ceramic planter is now broken. So we didn't expect it to pop up. So it's not foreseeable. Therefore, prosecutor, you should let us go. Or similarly, hey, I was mad and I threw the baby bottle this way, and I didn't expect at that time that someone was walking down the hallway and it hit them in the head, right? So that's more of an accident. They might claim it as a crime. Very fact-based about how we need to deal with these things. So if an accident does happen and you're choosing to talk to the police, just maintain, look, I didn't intend the outcome. I didn't do this volitionally. It was an accident in the fact that whatever happened, it was more like the wee slipped from my hand as opposed to, hey, I just meant to scare him by throwing it over here. So hopefully that makes sense. That's a concept that I want you to know about, and I want you to use it to protect yourself. So if you found this useful, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you got a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this more than 25 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.